before I go back to clause 5, just picking up on the court's factual question as to when, in fact, the vessel arrived at Qingdao. That is the 26th of July, 2021, and I take that from paragraph 4 of the award, which is on page 10 of the supplementary bundle. So that is then within the delivery window. My Lords, then returning to clause 5, so we're back in page 107 of the court.
Just picking that up, so you were in breach of contract in not delivering on the 26th of July.
So there was something of a debate. So what happened, my Lord, is if we go into the award at page 10 of the supplementary bundle,
yes,
what happened was there was an anticipated berthing on the 31st of July. That was then cancelled because there was a separate dispute. And it appears that a berthing was then refixed within the window the 13th to the 15th of August. I understand, in fact, that it was then the 14th of August, but we failed to deliver by that date because of errors made in relation to arranging flights, as Mr. Lewis has explained.
Right. And that's the first period of
negligence. So that is the first period of negligence, yes.
Yes, and you've been required to pay damages for that, which is the loss of profits.
We have, and obviously one of the points that Mr. Lewis makes is, well, if not loss of bargain damages, what else? And we will. One of the answers we have to that is plainly you are entitled to loss of profit applicable to the period of delay.
Yes.
And indeed, these buyers have recovered $1.6 million of damages referable to that delay.
But that's referable to that delay.
Indeed.
And this is an argument about a second period.
It is. Yes. And before the judge, I think the judge, sua sponte, as it were, raised a question of double recovery. Which you may have seen.
Yes, but you're not taking that point.
No, we're not taking that point. We accept that, first of all, probably wouldn't be open to us given the way that it evolved procedurally, but in any event, is not a point that we would put.
But I'm just trying to, I mean, it's a bit complicated on the facts of this particular case, but suppose you have a much simpler case in which the only facts were your last voyage terminated on the 26th of July. You have a clause in terms of a laden voyage clause. Therefore, by not delivering on the 26th of July, you're in breach. How does that affect the argument as to whether you need to give notice of readiness by the cancellation date, which is not until about another month later?
Well, on my submission, it cuts across it for the reasons I was outlining before lunch. The question is, particularly in circumstances where there is no obligation spelt out, how does one, if you like, stitch together an obligation, whether an absolute obligation or one of reasonable care and skill, to deliver by the cancelling date in circumstances where there is, in fact, an absolute obligation to deliver at the end of the previous laden voyage, which is undoubtedly an absolute obligation that the parties have agreed by way of bespoke addition to the printed form. And we say that it is also inconsistent with any sort of implied contractual duty, because, and again, I'll develop this if need be, if the orthodox test for the implication of, say, the Democritus type term is one of necessity.
You don't need it because you've got an express obligation. But it still means that since on the facts that the last laden voyage came to an end well before the cancelling date, you were under an obligation to deliver well before the cancelling date.
Yes. And subject to this particular addendum.
Yes.
But in principle, again, if it was a simple case of this was the clause, these were the facts, then there would be a separate claim for breach of that obligation But importantly, that would not be a claim for compensation under Clause 14 at all.
It would just be for breach of contract.
Exactly. It would be a simple common law damages claim for breach of the laden voyage clause.
Right. Thank you.
Doesn't it depend a bit on what delivery really means in that clause?
Well, it would.
The laden voyage clause. I mean, delivery in the context of buying and selling ships is a bit more than just parking the ship in a port and walking away. And this contract contains all these, I call them elaborate, not to be rude about it, elaborate provisions to deal with the necessary things you have to do, giving notice of readiness, letting people know. That's what this means, doesn't it, when it says delivery?
Yes, I accept that. So it would.
It doesn't relieve you of an obligation, for example, to give notice of readiness.
Where in the laden voyage clause it says shall affect delivery, that must in context mean tender for delivery, because clearly there can't be physical delivery until the queries are ready for handover.
But it means, doesn't it mean give notice of readiness? Yes, notice of readiness.
Yes, that would be part of it.
Yeah.
So why is this a difficulty contractually? Because you have an obligation to deliver. You then have the cancellation date provisions, whereby if you do not serve the notice of readiness by that date, they can cancel.
Yes. On my case, there's no difficulty at all. There's an obligation to deliver at the end of the last laden voyage. If we breach that, then there's a claim for damages. One then adds to that a right to cancel if notice of readiness hasn't been terminated, hasn't been given by the cancelling date.
And if it hasn't been given by reason of your negligence, then there's the right to compensation under 14b.
Yes. But of course that then begs the question as to what is meant by that.
Exactly.
Yes.
But insofar as the judge proceeded on the basis there was no obligation to deliver, that must be wrong.
Well, I think again we need to be. She found that there was no obligation. I think it's worth turning that up because it may be an important point. I think Mr. Lewis took my lords to paragraph 15 of the judge's judgment, and at paragraph 15, this is at core 86. And it is true that what she said was that there is thus, having referred to clause 5 in the printed form, no positive obligation to deliver or tender notice of readiness, nor be ready to complete a legal transfer by the 20th of August 2021 or any other date. Again, reading the judgment fairly to this experienced judge, my interpretation is by any date certain. I don't think that anyone was suggesting that there wasn't an obligation to deliver at the end of the last laden voyage. And indeed, both Learned Friend and I addressed her on how the last laden voyage clause fit with our respective constructions. So, again, although Mr. Lewis seeks to put a fissure between our position and that of the judge, I don't think there is, in fact, any inconsistency. We would read paragraph 15 as saying there's no obligation to deliver by a particular date, rather than saying that, at least in this MOA, there's no obligation to deliver by any date at all, which we accept can't be right given the laden voyage clause.
But in construing clause 14, we have to bear in mind that it's a standard form, which doesn't include the laden voyage clause.
I can see some faults to that, but ultimately one is construing this particular contract.
One can't say that the insertion of that clause had a fundamental effect on the interpretation of clause 14. Can we?
There may be two different questions. The first is the interpretation of clause 14. The second is whether or not one needs to imply the sort of Democritus term that Learned Friend contends for. I accept that the laden voyage clause is unlikely to bear on the meaning of clause 14.
But the judge did seem to regard it as important in her interpretation of clause 14 that she saw that there was no that the sellers were not in breach
Yes.
of an obligation to deliver.
She did.
But I think you're accepting, in this case, they were in breach of an obligation.
Indeed, for which damages were awarded.
And secondly, do you accept, do you disagree with her view that that is an important factor in construing Clause 14?
I think when it comes to ground 2, I can see that the laden voyage clause is of much lesser importance. The reliance I place on the laden voyage clause is principally in the context of ground 1, and even within that.
But ground 1 is only relevant here insofar as it relates to Clause 14, so I think it's got to be very careful to keep closely focused on what's really at stake here.
I can quite see that. But it was
arguing about ground 1 on the basis of the inclusion of a bespoke clause which can't affect the meaning of Clause 14 seems to me to really be going well off the Section 69 question we have to answer.
Well, my learned friend had placed himself some reliance on the laden voyage clause at para 30 sub 6 of his skeleton at core 36. I'm simply pointing out, actually, if one is going to have regard to it, the force goes the other way. But I can see that if one is simply looking at the standard form, then staying with that all the way.
Can I tell you what's to say to me, Mr. Wright? I can see entirely that because Clause 14 is a standard form,
Yes.
one would assume that it should be interpreted as a standard form. Its interpretation should be changed.
See that.
But that doesn't mean that its application in a particular set of circumstances might not be affected by the existence or not of an obligation of the kind that's being debated, whether the contract, whether it was drafted in such a way, I'm going to put it this way, on the assumption that there was no such obligation, as you put it in your case. But in fact, in this case, there is such an obligation. And that won't affect the construction of the clause, but it might affect how the clause works when that construction is determined.
Potentially,
On the facts of the case.
Save for the fact that any remedy that arises under Clause 14 is anchored to a failure to give notice of readiness in accordance with Clause 5b, or fail to give validly completed legal transfer by the cancelling date. So Clause 14 doesn't refer back to the laden voyage clause. If there is a claim for breach of the laden voyage clause, it's one that simply arises at common law. So, my lords, that does then take me back to Clause 5b and the notice provisions, first of all in lines 80 to 82. So these are the obligations to send a succession of notices as to the intended date on which the sellers will tender NOR and the intended place of delivery. The clear purpose of that clause is to provide the buyers with an elevated level of certainty. So within the 1 month delivery window that we were discussing before lunch, the buyers have some idea in advance when within that window the vessel is in fact going to be tendered for delivery. And we say that that is one of the other answers to Learned Friend's insistence that one needs to construe there as being some obligation because of commercial certainty. We say, in fact, there is a carefully calibrated scheme that provides the buyers with the requisite certainty because you have the 1 month delivery window, and then even within that window, you have the succession of notices aiming towards the precise date. Lines 83 and 84, when the vessel is at the place of delivery and physically ready for delivery in accordance with this agreement, the sellers shall give buyers a written notice of readiness for delivery. I think my learned friend places some reliance on this, saying, again, there is plainly obligations in this line concerning delivery when the vessel is at the place and physically ready. But again, that doesn't take him any further because those particular lines use the express language of obligation the sellers shall give. Now, clause 5C, as the court will have seen, provides a mechanism by which the cancelling date might be extended. And one of the limitations on that mechanism is that the sellers are only entitled to request an extension if they anticipate that they won't be able to meet the original cancelling date, notwithstanding the exercise of due diligence by them. And what Mill and Friends say at paragraph 30 sub 3 of their skeleton at core, page 35, the submission is made in the second sentence of that sub-paragraph that this presupposes the existence of NOR and readiness obligations, which are at least duties of care. We say that is simply a non sequitur. What the words notwithstanding the exercise of due diligence by them are doing in clause 5C is qualifying a right vesting in the sellers to request that extension. Those words do not give birth to any obligation to exercise reasonable skill and care. And moreover, clause 5C is predicated on the seller's anticipation when they make that request. So it is perfectly possible for the sellers, good faith, I accept, to anticipate that notwithstanding the exercise of due diligence, they won't be able to be ready. They make a request, and it turns out later on that in fact they were negligent. The two are not simply two sides of the same coin. And my lords don't have to take my word for that. The tribunal itself addressed this issue. If we can go to page 17 of the supplementary bundle, at paragraphs 58G, the tribunal observed that the fact that clause 5C includes the words notwithstanding the exercise of due diligence does not mean it will be assumed that there will be no proven negligence. The two are simply not synonymous. As I say, what those words are doing is qualifying a right otherwise vesting in the sellers. Then at clause 5D...
Before you leave 5C then,
yes.
What concept could there be of due diligence to deliver by the cancelling date if there's no obligation? How would you measure what due diligence is if you're not obliged to do it?
So there are two questions. The first is whether due diligence is the same, if you like, standard as negligence, and there's some suggestion in Strong and Herring that the two are different. We don't endorse that. The absence of due diligence is the same as negligence. But my point is a slightly different one, which is that what those words in line 85 are doing is saying that the sellers are not entitled to request an extension for the cancelling date if they could meet the original cancelling date with the exercise of due diligence. And the importance is that once the request is made, the sellers, as your lordship sees, notifies the buyer in writing, stating the date when they anticipate the vessel will be ready for delivery and proposing a new cancelling date. Once that notice is sent, the buyers have the option either of cancelling forthwith within 3 running days, or accepting the new date as the new cancelling date. And if they don't make that election, they are deemed to accept the new cancelling date.
Isn't it also a thing that, because this is about the seller's anticipation.
Indeed.
And so the exercise of due diligence, in a sense, I'm going to call it a thought crime. And what I mean by that is it's all about what the sellers are thinking. It's not about what they're actually doing. But what it would mean, and I think the arbitrators picked this up, didn't they? That if the sellers take that option, as it were, they can't deny later that they could have done it with the exercise of due diligence, because they had to have anticipated that they couldn't.
Yes. Yes, I see that. I see the force in that. But of course, on the facts of our
Yeah,
case,
it may not matter on the facts of this case. I don't know.
And then clause 5D, the reliance that is placed by my learned friend is in relation to the claim for damages. And just reading the clause in full, cancellation, failure to cancel, or acceptance of the new cancelling date shall be entirely without prejudice to any claim for damages the buyers may have under clause 14 for the vessel not being ready by the original cancelling date. And there are 3 points that arise here. First of all, the words without prejudice to are plainly words of preservation. They are not redolent of a situation by which cancellation can birth new claims for damages. The second, and this is a point that is prayed in aid under ground 1, Mr. Lewis says, aha, this refers to a claim for damages. How, he asks, can there be a claim for damages without a breach of obligation? One has to be a little bit careful here because it refers to a claim for damages the buyers may have under clause 14. But of course, in fact, if one goes to clause 14, page 113, there is in fact no adoption of the word damages at all as distinct from due compensation.
That means that 5D is an aid to interpretation of what undue compensation is, then, is it not? Because you have to read the two clauses together.
Yes.
And the parties in 5D have described that as damages.
They have. Clearly, it is contemplating some form of monetary remedy under what has been termed clause 14b. But what it doesn't say is that the buyers have or may have any common law claims. So it is pointing towards the monetary remedy being found in clause 14. It doesn't point to common law damages for breach of an obligation more widely.
What other sort of damages could there be here? Because if it's a contractual right to a payment, it's not damages, is it?
Well, this is where I think my own friend and I part company. I accept that under clause 14b, if there is negligence, there is a contractual right to payment. The issue then being, if you like, how one measures that.
Yes.
Mr. Lewis's analysis is that, in fact, because there is an obligation, you're entitled to damages at common law, and 14b effectively tops that up by entitling you to loss of bargain damages in circumstances where you wouldn't be entitled to those at common law. But the point that I am making is that a failure to deliver by the cancelling date, even with negligence, leads to the sole remedy arising under clause 14, which is not a common law remedy, and that is consistent with the judge's analysis on ground 1.
I thought it was a simpler point Mr. Lewis was making, which is the use of the word damages to describe what you get under clause 14. A failure for the vessel not being ready by the original cancelling date demonstrates that the contract as a whole regards the vessel not being ready by the original cancelling date as being a breach of contract, because that's what damages refers to breaches of obligations.
I think that is his point. But the difficulty is that it refers to damages under clause 14, but clause 14 itself does not refer to damages. That's the difficulty. So
but clause 14 refers to compensation for loss.
It does.
Now, I entirely accept that it's open to parties to stipulate that A will pay, B some money in certain circumstances without it being implicit in, necessarily implicit in that those circumstances involve a breach of contract.
Yes.
You can just have a contractual payment.
You can.
But as my lord said a moment ago, you have to read clauses 5 and 14 together.
Cool.
Clause 5 does cross-refer to what you get under clause 14b as damages. So why does that not lead to the inference that the contract does contemplate that the vessel not being ready by the original cancelling date is a breach for which damages are payable in the shape of compensation for loss, rather than just a contractual payment?
The problem is there, as I say, there's a looseness of language between clauses 5 and 14. Damages is not being used in the technical sense in my submission. It is simply referring to compensation and whether one characterises that as contractual compensation.
So 5D is actually inaccurate. It should have said to any claim for compensation that buyers may have.
Yes.
Yes.
And that would be consistent with the clause 14 remedy being the sole remedy. Because if it had just said any claim for damages full stop, I could see the force of Mr. Lewis's point. But it doesn't say that. It goes on to define that remedy solely by reference to the contractual terms of clause 14. And the third point is, as the judge observed at paragraph 46 of her judgment, the claim under clause 14 is for the vessel not being ready by the original cancelling date. So it's tied to delay and not discharge. So again, happily on the facts of this case, we can see precisely the sort of claim that was made and was successfully made, which was in relation to the first period of negligence, for which, as I say, the buyers recovered a substantial award. So that's clause 5. We've spent some time analysing what it does say, but of course the obvious point made by the judge is what it does not say. It does not say that the sellers are obliged to tender NOR or be ready to effect legal delivery by the cancelling date in terms. And given clearly that elsewhere in that clause, the parties have used languages of obligation, we say that construing that clause as a whole, the absence of similar language is significant. And indeed, Professor McMahon, which in an article which my own friend otherwise places some reliance on, at least on this point, agrees with the judge's analysis. If we can go into the authorities bundle to page 451, in the third paragraph of that on page 33, having discussed clause 14b, he goes on to say, was there a breach of contract? The judge concluded that clause 5 of the contract imposes no positive duty to complete by the cancelling date. And then says, clause 5 certainly imposes no strict duty. In the absence of seller's proven negligence, the cancelling buyer receives only its deposit, but then he goes on to adopt the Democritos analysis. So he says that although clause 5 does not itself impose any duty, in common with the analysis now put forward by Mr. Lewis on the Democritos, he suggests that there's some implied term of reasonable diligence, but that is not a duty that one gets from the wording of the actual MOA itself. Then if we come on to clause 14, this is now page 113 of the core bundle.
There's some difficulty with that, in the concept of the fact that the contractual remedy is the right to cancel a loan and return the deposit doesn't mean it's not a breach.
It can be a breach. It cannot be a breach. Ultimately, it will depend on the wording.
No, but that's the professor's rationale, isn't it? He's saying because all you get is the deposit back, it can't be a strict duty. I don't follow that.
Well, certainly this part of the reasoning is fairly functory, and it may well be that ultimately this article is of limited assistance on the other points too. But it's clearly an article that Malone and Friend praise in aid, and for what it's worth...
You're perfectly in no way criticising you for referring us to it. I'm just wondering whether it stacks up.
Well, maybe so. And then, my Lord...
Can I just be absolutely clear? I mean, looking at Clause 5,
Yes.
if you read Clause 5 as a whole, it's got a notice of readiness not before 20th of July, and a cancellation date 20th of August. And I'm not looking at the laden voyage bit, let's put that to one side.
Yes.
It seems very hard not to read that as a whole as saying, well, it's pretty obvious what's going on. You've got to produce the ship, or to be precise, the notice of readiness of the ship, which is a precursor to the actual delivery, by the 20th of August and not before the 20th of July. It's not really very complicated. Only a lawyer would read this and torture it to death and come to a conclusion that there isn't actually an obligation to produce the ship by the 20th of August.
I'm not sure about that, my Lord. I think one of the other important factors which the judge did rightly rely upon is the analogy with time charter cancellation clauses. And these are obviously, these are participants within the shipping industry. If one didn't have that additional factor, then clearly Malone and Friend's case on ground one would be stronger. But these are participants within the shipping industry. They will be familiar with cancelling clauses, such as that in the time charters, and then subject to the question raised by the Democritus, it is well established that those cancelling clauses do not give rise to absolute obligations. But then, my Lords, coming on to clause 14, and I'm happy to adopt the rubric of clauses 14a and b. 14a, and it's important given the way that Malone and Friend develops his case by reference to, for example, language of default and failure and so on. The same language is to be found in clause 14a. So it's all headed seller's default. Then 14a, should the sellers fail to give notice of readiness in accordance with clause 5b, or fail to be ready to validly complete a legal transfer by the cancelling date, the buyer shall have the option of cancelling this agreement. And then there's also the alternative where NOR has been tendered, but the vessel ceases to be ready and it isn't put back into a state of readiness. And then provision is made for return of the deposit. Now, pausing there, it is common ground that absent negligence, there would be no right to claim damages or compensation, whether for loss of bargain or otherwise, absent negligence, and in the situation of clause 14a. It is not suggested that if there has been a non-negligent failure to deliver by the cancelling date, that one is entitled to common law damages. And indeed, on the right facts, you could even have a delay that was, even though not negligent, sufficiently prolonged that one could terminate at common law. Again, posit a situation where there was a prolonged delay because of issues with the cargo, for which the ship owner was entirely blameless. If that delay persisted for a frustrating period of time, one could have otherwise a repudiatory breach. But as I explained, it's common ground that in those circumstances, the buyers don't have a claim under clause 14a. And that is important because one has to test that common ground against the arguments put forward by Malone Friends. Suppose that a buyer wished to argue that it was entitled to common law damages, even absent negligence. that putative buyer's argument would proceed along very similar lines to those advanced by Malone and Friends on this appeal. They would point to seller's default, they would point to the reference to failure, they would point to the terms of clause 5, and they would point, no doubt, to the absence of any express exclusion of the right to common law damages. So, again, if it is right, and indeed it is agreed, that clause 14a gives rise to a bare right of cancellation and means that a buyer is not even entitled to claim common law damages for breach of what is said to be the putative delivery obligations, that then answers the question put down by Malone and Friend as to why have clause 14b at all. And this was in response, I suppose, to our respondent's notice point about accrued rights and clause 14b preserving those accrued rights. And he says, well, if you already have those accrued rights, what is the purpose of the reference to due compensation for their loss and all expenses? The point I am making is, even though it is not set out in terms, it is essentially agreed that where there is a non-negligent failure, there is not even a right to common law damages. That may well be because, as the judge said under ground 1, there is no obligation. Alternatively, it may well be because on the proper construction of clause 14a, that has the effect of excluding common law damages.
Well, that wouldn't be hard. That wouldn't be a hard construction to reach, given that 14b provides that you need to prove negligence to obtain the damage.
Indeed.
Or compensation.
Indeed. But on either analysis, that answers the question put down by Malone and Friend as to why have clause 14b at all. It is distinguishing a situation between clause 14a, where you essentially have no remedies other than return of your deposit, to clause 14b, where your common law damages rights, if you're against me on ground 1, are preserved. So that is the distinction. Whether one analyses it as no obligation or creation of a limited right, or exclusion and preservation, the point is that clause 14 plainly contemplates two quite separate regimes, but both of those are consistent with my case, which is that clause 14 is intended to reflect the common law compensatory principle if there's a breach at all. It doesn't extend that principle to allow a party to claim loss of bargain damages in circumstances where they would not be entitled to those damages at law.
Why do you say they're separate regimes? It seems to me that A provides the right to cancel.
Yes.
And B provides a further right, or another right to compensation, but you might have both, as the clause specifically
you do have
entails. And it seems to me that they're actually the same regime, which is if you haven't, they're both predicated on a failure to give notice of readiness by the cancelling date. And then there's the further question of whether that was due to proven negligence.
Yes.
So it's just one regime, isn't it? With an added requirement if you want to claim compensation.
Yes, I suppose when I refer to two different regimes, I mean two different regimes for negligent and non-negligent.
I think the point you were trying to make, wasn't it? You were trying to make a point from the fact that there's references to failure, etc. in
Yes.
A, but I don't think there's a distinction there. And I think Mr. Lewis would say, well, yes, I fully say that in A there is a breach, failure.
Yes.
Which is the same failure which entitles me to compensation if there is negligence.
But then what that doesn't answer is the question as to why you don't also get damages, common law damages, for breach of that obligation where there has been a non-negligent failure.
Isn't that
Because the clause says so.
Well, exactly. So there's effectively an implicit exclusion of the right to claim damages in non-negligent failure, but then that explains what clause 14b is doing, which is preserving. All this assumes that your lordship's against me on ground one, and that there is a breach of an obligation. But assuming that there is a breach of an obligation, what clause 14b is then doing is preserving those common law damages rights that are otherwise implicitly excluded where one doesn't have negligence. So that's a very straightforward distinction. It's saying non-negligence, you don't get anything. In case of negligence, you get due compensation for loss and so on. And I say that that is to be measured by reference to the ordinary compensatory principle of law. And then separately, one is entitled to all expenses, and the inclusion of those words, as Strong and Herring point out at para 1712, was to expand the ambit of the loss which could be recovered by the sellers. So there is a commercial balance to be struck here. The buyer is, under the express terms of the clause, entitled to all expenses, but it doesn't follow that the buyer is entitled to loss of bargain damages, absent repudiation. And one adds to that the fact that it is settled law that where damages are recoverable for loss of bargain, those may include wasted expenditure. So it is difficult to see why that bifurcation was thought necessary if loss of bargain damages fell within due compensation, because in those circumstances, the words all expenses would be OTOs. So, my lord,
because in certain circumstances there may be no cancellation.
Yes.
So then you may be claiming expenses.
Indeed. And I think one of the points that Mr. Lewis made is by reference to paragraph 48 of the judgment. He said, if we go to core 95,
yes.
He drew attention to recoverable damages under clause 14b, including expenses incurred by the buyers in making arrangements to crew the vessel and so on, and was critical of the judge's reasoning because he said, well, you wouldn't get those if there hadn't been a cancellation. That doesn't necessarily follow because, of course, one could have mobilisation costs for a crew that ultimately then aren't able to board because the vessel is delayed in its delivery even though the MOA hasn't been cancelled. So I agree the recoverability of all expenses may arise whether or not there's been cancellation. My point is a shorter one, which is that all expenses has been separated out from loss, even though if one was entitled to loss of bargain damages, and at least in the cancellation case, the reference to all expense would be OTOs. So, my lord, I've spent some time on the MOA, just then dealing with ground one itself. The first point to note, of course, is that there has been a move away from the strict obligation analysis, and although the buyers seek to characterise this as an arid debate, we say that there is real difficulty in the way that Mr. Lewis has now presented the matter to your lordships as one of a contractual reasonable duty of care. We say that that is not correct either, that in fact there was no strict obligation, that the alternative case on duty of care should also be rejected. And then I'll touch briefly on the authorities, and in particular the Solholt, which is, I think, really Mr. Lewis's best case so far as he concerns. In terms of the strict obligation, again, I've addressed the MOA itself, but just picking up some of the points made in Malone Friend's skeleton, if we go to paragraph 22 of his skeleton, page 33 of the core, So he starts at paragraph 22 with clause 14. That itself might be regarded as a little bit puzzling in circumstances where the clause that the obligation is said to sit is clause 5. So we say that that's a somewhat inauspicious start. But in terms of the points that are made on clause 14, first of all, reliance is placed on the words fail and failure, and it's said that that is synonymous with neglect to perform an obligation. In truth, we say that failure simply means not doing something or being unsuccessful. We gave 2 examples from the MOA where, for example, there's reference to failure to cancel, to failure to undertake an underwater inspection, but in neither case can there said to be an obligation. One can give other examples such as failure to give notice, for example, to invoke force majeure. Failure just means not doing something. It doesn't connote breach. Default, there are 3 points to make here. The first is that the word default is only found in the heading. As we've explained in our skeleton, that is a weak guide to construction. The second is that default is not, as a matter of language, necessarily coterminous with breach. An obvious example of default is an insolvency event, and that may not be a breach of contract. Third, as the judge explained, in truth, the different headings of clauses 13 and 14 are simply intended to distinguish between matters falling within sellers' and buyers' control. I think, briefly need to deal with the ABC electrification case, which Appellant and Friends rely upon. That is at tab 20 of the authorities bundle, starting on page 318. And as Mr. Lewis explained, in that case, default was regarded as synonymous with breach. The easy explanation for that is if one goes to the clause in question, which is paragraph 14 of the judgment, page 322 of the bundle, the words in question included within disallowed costs any cost due to negligence or default on the part of the contractor in his compliance with any of his obligations under the contract. So in those circumstances, it is unsurprising that default was given the meaning that it was indeed given in that case. And one can see that underscored in the judgment of Lady Justice Carr, as she then was, paragraph 37 on page 326. One sees in the final part of that paragraph, the relevant obligation was expressly linked to the default in question, where the clause itself identified the relevant duty. The default is most naturally to be construed as referring to a breach of that duty. But that doesn't really take Appellant Friend further anywhere. It is simply a decision on the particular wording of that clause. So that deals. And I've addressed also Appellant Friend's reliance on the cancelling clauses at paragraph 26. I'll come back to the democratos. Then at paragraphs 28 to 31, he addresses clause 5. And again, I hope I've addressed those points when we were looking at the clause itself. First of all, paragraph 29, the so-called asymmetry. And I've explained the position on the delivery window with there being no asymmetry because of the difference in wording, but also the certainty given to the buyer by the right to cancel. Paragraph 30, 30 sub 1, the notices are in fact consistent with my case because they explain how even on my construction there is the certainty required. Para 2 is nothing to the point because that is not tied to the cancelling date. And para 3 we looked at in the context of clause 5c. Nothing turns on that. Subparagraph 4, this is the damages point that we've obviously debated. Para 5 is just a very general appeal to reading the clauses together. And then Para 6 is the laden voyage clause, which I think ultimately we're all agreed is likely to not really affect at least the printed form. Para 31 is the point on the heading, and again that is extremely weak support for his case. So in truth there is very little that he can rely on in the text that points to his being the correct answer to ground 1. So far as commercial considerations, paragraph 32, although it appears under the rubric of commercial consequences, is in fact just a tying together of his previous textual points, drawing these threads together. And then paragraph 33 is again just a reprise in the main of his previous points. The first is the suggestion that because you are obliged expressly to deliver at a particular place when the vessel is there and physically ready and in the right condition, that one ought to imply an obligation to, or to find an obligation to tender delivery by a particular date, but that simply doesn't follow, not least given the different language involved. 33.2 is the clause 5D damages question that I've addressed, and 33.3 is the canard that sellers would be under an obligation to tender NOR or be ready to deliver by any particular date. But for the reasons I've explained, in fact, on this MOA one has the laden voyage clause, but in any event, any uncertainty there is catered for by the right to cancel as distinct to the right to claim damages. So, my lords, there is nothing in the wording of the MOA or its surrounding circumstances that would support the existence of the absolute obligation. What of the alternative case on duty of care? One can see a superficial attraction because of the Democritos. Again, one has to ask, what is the juridical basis for that duty? It is most unlikely to arise in tort. There is nothing in the express terms of the MOA that could find a reasonable care obligation. So it would have to be implied as a matter of contract. And although clearly the Democritos is binding authority in the time charter context, that such an implied duty exists, as your Lordship will have seen, the judgment of Lord Denning was rather brief as to the basis for that implication. But applying the ordinary test for necessity, again, one has to ask, particularly in the context of this MOA, given the laden voyage clause, can it really be necessary for there to be the implication of a reasonable care obligation to deliver by the cancelling date in circumstances where the parties have in fact inserted an absolute obligation to deliver after the end of the laden voyage? Insofar as it is necessary to consider the position even in the standard form, it is difficult to see why that necessity arises, given, first of all, the buyers having an express right of cancellation that gives them contractual certainty. Secondly, the buyers have an express right of compensation under clause 14b in cases of negligence. And thirdly, we say that if any term is to be implied, it is difficult to see why that shouldn't be the ordinary term in the Sale of Goods Act of one to deliver within a reasonable time. One then adds to that the fact that, as I have explained, there is in clause 5 a careful and detailed mechanism for the time and place of delivery, with a delivery window, a mechanism of notices, and a detailed regime for extensions of time. We say that in those circumstances, there is a detailed regime in which it would be inconsistent or at least unnecessary for there to be some superadded implied contractual duty of care.
If, just going back to the contractual, straightforward, absolute duty, if there was not the laden voyage clause, and we just had the standard form, what do you say would be the seller's delivery obligation?
There would have to be an implied obligation to deliver within a reasonable time, which would then be implied by statute. But that is different to the supposed obligation to exercise reasonable care to deliver by the cancelling date. It may, on the facts, lead to the same date, but the juridical basis and the content of the duty would be different.
So despite, as my lord said, there is a very clear structure here where there is the earliest date and then there is 1 month later a date upon which there is a right to cancel. The parties would be left with the uncertainty that the seller would only have to deliver within a reasonable time, which might be after the cancellation date.
And the remedy for that is that the buyer would be entitled to cancel, and if the failure to meet the cancelling date was through negligence, he would be entitled to compensatory loss and expenses.
Well, maybe we're coming back to this, but I have difficulty in understanding the concept of negligence if there is no duty to deliver, because how can you judge whether somebody was acting reasonably to deliver by a particular date if they're not obliged to do so?
Because if we go back to clause 14, so this is 113, the failure rests in not giving notice of readiness by the cancelling date. So one can even if that were not an obligation, one could still test the conduct of a party against that yardstick. So it's not that there's a breach of obligation.
When you're talking about negligence, then that does suggest the failure is a breach of some form of obligation.
Not necessarily, because as I think is common ground, one can have a contractual right to payment, hopefully using a neutral term, in circumstances where there has not been a breach. And one of the circumstances in which there is a contractual right to payment in this MOA is where there has been a negligent failure to give NOR or arrange for legal readiness. That isn't in any way dependent on either of those matters being a breach. It's simply, if you like, can you establish as a matter of fact those factual matters?
If they've made arrangements for the dealing with the vessel so that it is not ready to be delivered by the cancelling date, that may be foolish because it means that the buyers accrue the right to cancel. But in what sense is it negligent if they aren't obliged to deliver by that date? They've made a perfectly sensible arrangement to deliver by the date they're contractually obliged to deliver, namely the date upon which a reasonable date for delivery.
The question arises, so in line 348, the question that arises as a matter of construction is what is meant by their failure. That must be a failure to give notice of readiness by the cancelling date. Yeah. That is simply referring to a state of affairs. Yeah. It doesn't necessarily assume that has to be an obligation.
Well, negligence does. Negligence must be a breach of some form of duty.
Not in the particular context of this clause. One can have a failure which is not... So suppose, for example, I gave some examples of notice provisions. You could have, for example, a right of force majeure that was conditioned on a giving of a notice. You could have a clause that says failure to give notice where that notice as a result of the failure of negligent failure by the party invoking force majeure, shall disentitle them from claiming that right. So the mere language of negligence isn't coterminous with breach, in my submission.
If you have a clause which says you don't have to do this by a certain date, but if you don't do it, then your failure to do, or your non-doing of it, may have consequences if it was negligent. How could you ever know whether it was negligent or not if you weren't obliged to do it?
Because as I have explained, one is talking about a state of affairs.
No, but forgive me. I know you've made the point as being the answer to this question by saying you can have contracts which have these terms in. That's what you've just said.
Yeah.
I understand that. But that doesn't feel to me, at least, and I'm trying to give you one more chance to answer the question the way I'm trying to ask it.
Of course.
As how you can work out whether the non-act, the act of not doing something, or the non-act of doing it, there's a date by which what the contract says is if you don't do this by this date, how can you work out whether the inactivity was negligent unless you had some obligation to do it by that date? It's not about what contract terms say, it's about how you apply the contract term you're talking about. The point that's being put to you is that the only way you can answer the question of whether that was negligent is because there must by measuring against some duty to do it by that date. And your case, I know, is you say there isn't one. I understand that. And you say there are contracts which have these terms in, okay, by that. But it still doesn't help me understand how you can measure whether the non-activity, I'm trying to avoid using the word failure, was negligent or not, unless I've got some standard of conduct, some obligation to do it by.
I suppose that the way one would test it is to posit a situation where there must first of all have been a failure to tender NOR or arrange for legal readiness by the Council date for one to even get into clause 14. Mm-hmm. The question then arises on the facts: why has that come about? Mm-hmm. And then one investigates, if you like, what a reasonable party that would be aiming, whether or not it's a matter of obligation, but aiming to tender NOR by that date would have done. So that is how one tests it.
So you do test it by positing somebody trying to do the thing.
Yes.
Which you say
you're a notional obligation, but not a real obligation. You test it against a notional obligation.
Yes, I think that's certainly one way of putting it. Yes. And then just dealing briefly with the sole hold. So this issue, this question of obligation and recoverability of particular compensation only arose before Mr. Justice Staunton, as he then was. It wasn't a point that was taken on appeal. I don't agree necessarily that it was the ratio, because of course the claim failed. And what we do say is that in any event it was distinguishable, not only because of the positive obligation, but also the different wording of the clause, which we'll come on to. And if we go then to the sole hold, which is in tab 5, page 35 of the authorities bundle. And Mr. Lewis has shown you the key clauses. And just to refresh your Lordship's memory of those, they appear on page 39. So clause 14 is the seller's default clause. And then importantly, at the foot of that clause, the words, the sellers shall, in addition, make due compensation for any loss caused to the buyers by non-fulfillment of this contract. And that is wording that appeared in the then 1966 form, which were then taken out and obviously do not appear in clause 14 of our MOA. Then clause 17, you have what the judge rightly regarded as the delivery obligation, vessel to be delivered at safe port with 31st of August 1979 cancelling in buyer's option.
Does that impose an obligation to deliver by 31st August 1979?
The judge certainly considered that it was a stronger delivery obligation than the ones in the MOA. We would endorse that reasoning, but even if your lordships were against me on that, we have the point of distinction being the closing words of clause 14.
Well, yes, but those are two quite separate. They're logically quite independent
I see
points.
that.
And I understood from your skeleton that you were maintaining that under the 1966 form there was a positive obligation on the sellers to deliver by a particular date. But I have to say, looking at clause 17, it doesn't say that. It says where it's to be delivered, as does our 2012 form. And it has a date, which, I mean, the grammar is a bit compressed, but it just says, with 31st August 1979, cancelling in buyer's option. Why is that any different from ours, which says we've got a cancellation date also the 31st August? And that triggers clause 14, which gives the buyer an option to cancel. Just looking at clause 17,
Yes.
it's not obvious to me why that, if you say it does, imposes any express obligation on the seller to deliver by a particular date.
I can see the force in that, and I can see that perhaps to the extent that the judge regarded as that as a point of distinction, that is plainly weaker than what we suggest is the better point, which is the language of clause 14, which plainly is different. And although Malone Friend said that the clause 17 point was the, I think the way he put it, the basis upon which she distinguished the sole hold, in fact, if one goes to core 96, paragraph 54.1 of the judgment, the learned judge said this was a decision on the NSF 1966 wording, which is set out in paragraph 49 above, was very different. On this wording, it's unsurprising that Miss Justice Staunton held that the clause itself contemplates that the buyers may cancel and therefore the contract will be wholly unperformed, as far as its main object is concerned, that is to say, transfer the property in the vessel, is that loss which, in my judgment, plainly provided for in the words, loss caused to the buyers by non-fulfillment of this contract. So those, as the judge pointed out, are words that did not then appear in our MOA. And although it is right that the judge went on to say, moreover, as appears from the head note, there was in that case a positive obligation on the sellers to deliver no later than 31st of August. Even if the judge were wrong on that particular point, the first point would be plainly sufficient justification for distinguishing the sole hold. And indeed, if one goes back to paragraph 49, which was the cross reference in 54.1, the judge records at paragraph 49 on core 95 that she was referred by both parties to the drafting history of clause 14, and she points out that in this regard the wording of the original NSF 1966 was very different and provided expressly for the sellers to make due compensation for any loss caused to the buyers by non-fulfillment of this contract. So that may be the stronger ground on which the sole hold can be properly and should be properly distinguished.
Do you accept, this is something that Professor McMahon says, that there's a dictum of Lord Hoffman's, that where you have a standard form like this, which goes through a number of iterations and is being the subject of authority from time to time, that's I think he refers to it as a dialogue between the courts and the drafters.
I think there are two responses to that. We don't, I'm afraid, have the REWA in the authorities bundle, although I think we cited it. We ultimately, perhaps wrongly, took the view that it wasn't necessary to be in the bundle, but there is certainly more recent authority that deprecates what's sometimes called the archaeology of the forms. But even if one were to adopt Professor McMahon's analysis of this dialogue, how does the dialogue run? We said the dialogue runs that the words by non-fulfillment of this contract were taken out of the subsequent versions of the NSF form in circumstances where that was the subject of judicial decision in the sole hold, and indeed the Al-Tawfiq, which in truth adds nothing to the sole hold. But in circumstances where those words have been taken out, even if one were to get into this archaeology of the forms, we say the intentions of the drafters must be that a different result was intended, because those words have been taken out.
I can see that the words, well, you're obviously right, the words have been taken out, of course. Well, or to perhaps be a little bit more accurate, the words have been replaced.
Yes. Because
the sole hold words are caused by, and then it says fulfillment of the contract, and 14b certainly doesn't say that, but it still has caused in it. Hasn't it been replaced by the concept of failing to give notice of readiness by the cancellation date, which is, one might think colloquially, a pretty good synonym for failing to fulfill the contract, because that's really what the contract requires the seller to do.
so there were a number of changes there.
And added the negligence proviso.
Indeed, so it added the negligence proviso. But what it certainly changed, if you like, the trigger. Mm-hmm. So, and under the NSF 66 form, it was simply if default is made by the sellers in execution of legal transfer. It's now changed to failure to give NOR or arrange for legal readiness. Mm-hmm. But so far as the remedy is concerned, mm-hmm. and that's what we are really, in my submission, concerned with, mm-hmm. it is at that point that the words by non-fulfillment of this contract were taken out.
Yes, but what has been replaced by is their failure is due to. That's what replaces it. And the failure it's talking about is the giving of notice of readiness, which, as
yes.
I say, could be thought to be pretty close to being the same thing as fulfilling the contract.
But that is adding the new negligence requirement.
Yes, absolutely, I agree.
Yes.
So it's narrow. It's unquestionably narrowing it in that sense, because
yes.
There's an extra condition.
Absolutely, and it is also narrowing it in terms of the recoverable losses, because the words by not caused to the buyer by non-fulfillment of this contract have been taken out.
Well, I understand that those words have disappeared, but what I'm putting to you is that they've been replaced by something else. They haven't disappeared completely. What they've been replaced by is the failure to give notice of readiness, because that's what the second word failure in 14b refers to in the same grammatical place, if you unpick the language, as the fulfillment of the contract, the role it played in the sentence in the sole hold clause.
I'm not sure I'd agree with that, my lord. If we look at the sole halt clause at page 39, the seller's default wording is introduced by if default is made by the sellers in the execution of legal transfer and delivery of the vessel.
Mhm.
And then there's also, although there's no concept of negligence, we do have the concept of the default arising from events for which the sellers are responsible.
Okay.
Those are then replaced by the failures as triggers.
Mhm.
You get a replacement of this concept of responsibility with one of negligence. And then the third relevant change, and perhaps the most relevant for present purposes, is that the losses are narrowed because of the deletion of the words by non-fulfillment of this contract.
Can I just push back on that? If you have a clause saying you can have compensation for any loss caused by X, why do you narrow it when you say you can have compensation for any loss?
Because one is then looking back at the compensatory principle, and I was going to come on to this distinction that I mentioned in my opening salvo, this distinction between a non-repudiatory breach that leads to the exercise of a termination as against a repudiatory breach that discharges the contract and where you are entitled to loss of bargain damages, either at common law or in the sale of goods.
Well, I do understand that that's the basis of your argument.
It is.
But just as purely a matter of language, it seems to be difficult to maintain that any loss is a narrower concept than any loss caused by X. One would have thought any loss caused by X is necessarily a subspecies of any loss. Or am I being stupid?
Well, that's certainly the way that Mr. Lewis puts it. I wouldn't agree with that, obviously. I think the point is that one is asking them what is the loss that is being contemplated. Plainly, he accepts it can't mean any loss whatsoever because it imports questions of remoteness and so on. So there is some conceptual limit to the losses that are recoverable. The question is, where does one draw that conceptual limit? We say that where that line is to be properly drawn is whether or not those losses would be recoverable in it under the compensatory principle, because then that gives effect to the two different regimes that I've explained, where you have a non-negligent failure.
I see that, but the 1966 version, which we're looking at in the sole hold, clearly is drafted on the premise that whether or not it's a breach by the sellers to fail to make default in the execution of a legal transfer or in delivery by the cancellation date, that can be accurately referred to as non-fulfillment of the contract, and that's not surprising because if the seller doesn't do it by the cancellation date and the buyer cancels, the contract's not going to be fulfilled. And is it really the case that by taking out the restriction on loss to loss caused by non-fulfillment, the intention of the drafters is to narrow the losses that can be claimed? It does seem slightly, I mean, this is the point the professor makes, but it does seem a slightly surprising way of restricting the loss by deleting those words.
This may come back to the distinction that I made right at the beginning between non-delivery and delayed delivery, whether or not a breach, coupled by the exercise of a contractual right of termination.
But the effect of delayed delivery past the cancellation date is, if the buyer cancels, the contract's not fulfilled.
But this is where Mr. Lewis runs into the line of authorities that I suggest actually, if you part questions of repudiatory breach, where one has a breach of contract, even assuming you're against me on ground one, even where there is a breach of obligation, that leads as a matter of factual causation to a termination under an express right. That is not itself a discharge of the contract for common law purposes, and it is not therefore a non-delivery for the purposes of Section 51 of the Sale of Goods Act. So this is an important point. If I can take it first of all by reference to Lord Justice Diplock, as he then was, in Financings, which is page 22 of the Authorities Bundle. So this was a case in which there was again, similar to how Malone Friend analyses it if he's right on ground one, a breach of obligation coupled with a right of termination which was conditional upon that. But then, as Lord Justice Diplock said, he was clearly, so this is about halfway down the page, he, that is the hirer, was clearly in breach of his obligation to pay 2 instalments on the due dates, but in the absence of any express provision to the contract, contrary in the contract, these breaches of a contract of hire expressed to be a duration of 24 months would not of themselves go to the root of the contract or evince an intention on the part of the hirer no longer to be bound by the contract. The owner's only remedy would have been to sue for the 2 instalments overdue, and their measure of damages would have been the amount of these instalments, together with interest at the rate of 10% per annum. And then over the page, and this is the passage to which Mr. Lewis took you, starting at the 3rd line, but if we go on from where he read, if it does not, i.e. if the contract on its true construction doesn't superadd any additional rights or remedies, then each party is left with such causes of action, if any, as had already accrued to him at the date that the contract comes to an end, but acquires no fresh cause of action as a result of the termination. So that's the point. You have your accrued rights to damages, assuming that there have been non-repudiatory breaches, but the fact that you then exercise a contractual right of termination doesn't promote those non-repudiatory breaches to a non-delivery or repudiatory breach for which you're entitled to loss of bargain damages. And more recently, again, this was considered by the Supreme Court in the Koss, which is at page 106. This was, as the court may be aware, a case in which the charterers, the time charterers, had failed to pay hire in breach of charter. That undoubtedly entitled the owners to exercise an express right of withdrawal that would have the effect of terminating the charter. So here again, breach of contract that as a matter of factual causation leads to the exercise of a termination clause, but that conjunction of factors does not entitle one to loss of bargain damages. And the reason for that is as explained by Lord Sumption at paragraph 7c. The second consequence is that any failure on the part of the charterers to pay hire when it falls due will not of itself entitle the owners to damages representing the loss of bargain or the expenses of termination simply because the owners respond by withdrawing the vessel. This is because the non-payment does not itself destroy the bargain or occasion the expenses unless in the circumstances it is a repudiation which owners have accepted as such. So whilst I understand why Malone Friend says this is all a matter of factual causation and therefore the judge ought not to have gone behind the tribunal's findings, in fact the analysis is rather different. The better analysis is whether or not the breaches in question have discharged the agreement, and if they haven't, we submit that it would require very clear words to depart from that ordinary common law principle in order to allow the recovery of loss of bargain damages absent a repudiatory breach. We rely upon two further authorities. The first is Professor Peel. So this is his article starting at page, the relevant part starts at page 4 to 5. And this is a discussion of the differences and similarities between contractual termination and common law termination. And at 425, under section 3, he notes that so far as termination itself is concerned, there is no distinction to be drawn between termination repudiatory breach and termination pursuant to contractual power. In both cases, the parties are released from any primary obligations falling due after termination, but are still subject to any which accrued prior thereto. Where the two modes of termination diverge is in the recovery of damages. In both cases, damages may be awarded for any breach of obligations which failed to be performed prior to termination, but it is only where the contract is terminated for repudiatory breach that a claim may be made for damages for loss of bargain, i.e. losses which accrue as a consequence of the premature determination of the contract. So I think Mr. Lewis suggested there was something effectively arbitrary about this, what he called a stop loss or a way of cutting losses. That is the default position at law where one has a contractual termination right, even where the exercise of that right is conditional upon and exercised as in response to a non-repudiatory breach. And indeed, buttressing that analysis, at the bottom of page 426, Professor Peel's analysis of financing and Baldock, the real basis of the decision in financings and Baldock, is that once the contract had been terminated, there was no further opportunity for repudiatory breach. If there had already been a repudiatory breach prior to termination, no such opportunity would be necessary, or to put it another way, the repudiatory breach has the forward-looking aspect that a non-repudiatory breach lacks. So that's Professor Peel. We've had two professors already. I'm afraid I'm going to try the court's patience with a third, which is Professor Carter. And he comments on this at 360. So 360, the sidelined passage, he describes the restriction on loss of bargain damages as nevertheless correct as at a doctrinal level. Two explanations can be found in the cases. The first is by reference to an Australian case, Chevron Builders Licensing, which is effectively the causation analysis. But then Professor Carter observes that the alternative analysis, explanation, can be found in financings and Baldock. Lord Justice Diplock explains that exercise of an express provision for termination activated by a breach of contract merely discharges the parties so that each party is left with such causes of action, if any, as it has already accrued to him at the date that the contract came to an end, but acquires no fresh cause of action as a result of that determination. So that's the passage I've shown your lordships. And then, for what it's worth, Professor Carter says at the bottom of that page that the analysis of Lord Justice Diplock is preferable, in particular once a common law right to terminate is established. A promisee is not required to prove a causal connection. So, again, this clear distinction between common law and contractual rights. Now, what I anticipate Mr. Lewis will say, and indeed has said, is, well, that is all very interesting, but ultimately the parties are able, as a matter of law, to modify that position. And I accept at a very general level that the parties could expressly spell out a right to loss of bargain damages upon the exercise of a contractual termination right, even where there has been no common law discharge. But here, as I explained in opening, first of all, an important contextual matter is that it is now common ground that the obligations of reasonable care or whatever are not conditions. That is important, first of all, because as I have explained, in circumstances where the parties did not make the obligation a condition, it would be counterintuitive that those same parties objectively intended clause 14b to then import the key incidents of breach of condition. So in other words, why is it, if the front door of breach of condition has been closed to Mr. Lewis, is it really credible to say that the parties left open the back door of obtaining the same damages through an express right of clause 14b?
Might it be said they built their own fancy door and tried to analyse it on the basis of what would have happened if they hadn't? Doesn't really help.
Well, but
my point being that with clause 14 in the contract, you can see that it's not a condition. But to take clause 14 out and then ask is it a condition doesn't really help, because clause 14 is part of the contract.
Well, my lord, my point is a slightly different one.
Mm-hmm.
Both the question of condition and the question of what clause 14b means are questions of ultimately construction.
Mm-hmm.
And if it is right, and it is now accepted to be right, that the putative obligation is not a condition, we say, in agreement with the judge, that in those circumstances, as she said at paragraph 42, page 93 of the core bundle, we endorse the judge's observation that it is a matter of common sense that where the parties have not made tender of notice of readiness by the cancelling date a condition of the contract, the court will need to be adequately satisfied that they nonetheless intended to provide for equivalent consequences by means of clause 14b. So that's the point. And one then adds to that the reasons as to why the judge was satisfied that this was not a condition, even if contrary to her view there was some obligation. And the judge was rightly concerned about the fact that failure to comply with the alleged obligations, which might arise from a wide range of culpability and carry with it a wide range of consequences, would lead to a situation where, if clause 14b had the effects intended for by Mill and friends, that would have draconian and disproportionate consequences. And my lord, although we both looked at Professor McMahon's article in some detail, one again passage your lordships were not taken to is 451. Professor McMahon, again for what it's worth, in the penultimate paragraph of his article, in fact concludes that there was a condition. And one can see the internal logic of that. One can see that if it's a condition, then in a way that supports the construction of clause 14b. But if in fact one is to accept, as my own friend rightly now has, that there is not a condition, then we say that very much tells against him on clause 14b.
The second argument really comes down to any more than this, to say that because when the buyers cancel, they haven't lost the agreement, they've actually carried out the agreement. And so due compensation, that doesn't include loss of a bargain because the bargain hasn't been lost.
The bargain hasn't been discharged, yes. they have exercised their contractual right. Absolutely.
Yeah. That's really what your argument comes down to.
Yes, it's a lot of argument about quite a short point. So, my lord, I think, need to address the clear words point, which arises on my respondent's notice. You had taken, I think, to Bungie and to financings. You were not taken, I think, to the two decisions of Mr. Justice Popplewell, as he then was, on which we rely. The first is Novacen and Alimenta. And I'll take your lordship straight to the paragraph upon which we rely. It's another gaffer default clause case. And the question was whether or not common law principles applied to that default clause on the Golden Victory. And if we go to paragraph 17, one of the issues, he first of all considered the well-established Gilbert-Ash principle that if one is seeking to narrow rights that would otherwise exist at common law, one does need clear words, and that's obviously a proposition beyond dispute. But then in paragraph 17, Mr. Justice Popplewell says the issue before me is the converse of that which was there being considered, which was whether a right to damages or other remedy conferred by law was excluded by contract. Whereas in this case, the question is whether the contract confers a right to damages where no such right would arise at law. So if my lords are with me on the financings, costs, and professors' Peel and Carter analysis, that is an accurate description of our case here. Nevertheless, in my view, similar principles should apply. The parties should be taken to have contracted against the background that their remedies will, in the absence of specific contrary agreement, be regulated by the system of law chosen to govern their contractual relations. If no remedy in the form of entitlement to damages is conferred by law, clear words will be required to confer a contractual entitlement to such remedy. And Mr. Justice Popplewell returned to his theme in the Spark Appellant, decided only a short time after, at paragraph 98, again discussing the distinction between, this is page 191 of the authorities.
Very lengthy and learned judgment.
It is. Most of it is taken up with the breach of condition question, which happily this court will not need to resolve. But on this specific question, Mr. Justice Popplewell said such an option to cancel, so that was the withdrawal clause in the NYPE form, leaves unaffected the innocent party's right to claim damages, which remain governed by the common law principles set out above. If there has been a repudiatory breach or renunciation, the right to damages is preserved. If there has been no repudiatory breach or renunciation, the option to cancel does not confer a right to damages in the absence of clear language to the contrary that merely confers a right to put an end to future performance obligations. So we say, particularly in circumstances where it is now common ground that there is no condition, Mr. Lewis has to show very clear words, certainly clearer than in clause 14b, to establish a right to loss of bargain damages where none would exist at law. And in that context, returning to clause 14b, we make the following points. First, an obvious point is that the parties have not expressly provided for loss of bargain damages, either by designating the putative obligations as conditions, or alternatively using the sort of express words that one sees in, e.g., the gaffer default clause, or potentially the older version of NSF 66 considered in the sole hold. Second, if one then turns to due compensation and just returning to the MOA, which is at core 113, as the judge rightly observed, the failure in question is a failure to give notice of readiness or be ready to validly complete legal transfer. That is not, for the reasons I have explained, synonymous with non-delivery for the purposes of Section 51 of the Sale of Goods Act, which is a repudiatory failure to deliver goods. This was a case of delayed delivery overtaken by a contractual right of termination. Third, as I have explained when we were looking at the clauses, Clause 14b makes sense in the context of there being no right to compensation in the event of a non-negligent failure, followed by cancellation under Clause 14a, even where a common law right would otherwise exist. So the scheme works by Clause 14b preserving rights to common law damages, but does not confer a right to claim loss of bargain damages where none exists. Fourth, I rely on the distinction that I've already drawn between loss and all expenses, and I've addressed your lordships on that distinction. In short, we say that due compensation is a reference to the loss associated with delay in tendering the NOR or being ready to physically deliver. It is not intended to set up loss of bargain damages because there has not been a non-delivery. It is not right, however, to say, as the buyers do at paragraph 50 of their skeleton, that they would never be entitled to loss of bargain damages if the failure to tender NOR or be ready to validly complete legal transfer persisted to the extent that it became repudiatory at law, then plainly in those circumstances there would be a claim for loss of bargain damages. There's nothing untoward or surprising about that. It simply reflects the general law. Coming then briefly onto the commercial consequences.
Can I just pick you up on that last point? So what this means is buyer, so suppose the mortgage has moved against the buyer quite dramatically, gets to a cancellation day. If you're right, he knows that if he's got a contractual right to cancel, but if he does that, he's not going to get his loss of bargain damages. So he has to take the risk of the arbitral tribunal in a year's time thinking when the delay has become sufficiently long to be repudiatory.
But, my lord, that's precisely the same as under the time charter cases. Mr. Lewis and I, for many years, used to litigate any number of time charter repudiation cases where you had a defaulting charterer who would occasionally pay higher in dribs and drabs, and the owner was always faced with the position, well, do I terminate, potentially throw up a lucrative charter so the charterer gets away scot-free, the stop loss that Mr. Lewis referred to, or do I press on until it's clear that it's repudiatory? But that's simply a function of a contractual right of termination that isn't a condition. It's not unique to this NOA. It's a well-known dilemma for participants in the shipping industry.
But might it not be said that the very purpose of putting in a date by which the seller has to be ready or lose the contract, run the risk of losing the contract, is to introduce certainty into what at common law is a very uncertain question, which is whether you've delayed sufficiently to make your conduct repudiatory.
But that then shades back into the argument on condition. And indeed, it was the same argument that was advanced and rejected by this court in the Spa Capella.
I see. Okay, thank you.
And indeed, as both the judge pointed out, and on this too, we say that she has the imprimatur of law assumption in the costs. We go back to page 106. Lord Cross observed, consistent with what the judge said at paragraph, I think, 57 of her judgment. I took your lordships to the second consequence, but starting in the third line of paragraph 7, the first consequence is that the owners will not exercise their right of withdrawal unless it is in their commercial interest to do so. Usually this will be because market rates have risen. It may be in owner's interest to withdraw the vessel even if they have not risen. For example, where the charterer is insolvent or owners depend on prompt payment, and so on. So this suggestion of commercial imbalance is simply a function of the fact that the buyers here have a super-added entitlement to cancel. That is, as the judge rightly said, itself a valuable contractual remedy, because, again, what it does do, even if the buyers are not entitled to claim damages for loss of bargain upon the exercise of that right, what it does give them is the certainty of knowing that they don't have to take the vessel if there is a persistent delay beyond that cancelling date. And then that is coupled with the fact that they can recover losses in the event that there's negligence. And indeed, my lord, one of the points that you rightly flag is that the buyers may face the dilemma of having to cancel when they don't know whether or not they can establish repudiation. But of course, that's also true of negligence. So there too, the buyers faced with this commercial decision as to whether or not they want to cancel will have to grapple with that question too. So the aim of clause 14, we say, is not to confer upon the buyers effectively quasi-breach of condition rights. It is to give them the certainty that is achieved by a withdrawal or cancellation clause, coupled with the preservation of their common law damages rights in the event of negligence. Two points were then made by Malone and Friends in relation to commercial consequences at paragraphs 56 and 57 of their skeleton. So this is core 43. The first point that is made is that on the judge's construction, it is said it is unclear what compensation actually means. The suggestion being that it would otherwise be difficult to determine. The obvious flaw with that argument is that it is common ground that one can and does have cancellation rights that do not create additional rights to damages. See financings, see the costs, see the discussions by Professors Peel and Cutt. However, those losses are plainly capable of assessment. And so the suggestion that, if you like, if Mr. Lewis is not right, the tribunal would be put into an impossible position, simply isn't correct. But in any event, the heads of losses that might be recoverable are readily ascertainable. The paragraphs 45 and 46 of our skeleton, 45 and 48 of the judgment. First of all, wasted expenditure under the rubric of all expenses. Secondly, loss by delay or non-repudiatory breach, including, of course, the 1.65 million that the buyers did recover for the first period of negligence, and loss of bargain damages if, but only if, there has been a repudiatory breach. The second supposed commercial reason is the commercial imbalance, and I have already addressed your lordships on that. That is a frequent incident of contractual rights of cancellation or termination, as we saw in the costs, and indeed, just completing the line of the time charter cases, the Spark Appellant. If we go to the, first of all, the judgment of Lord Justice Gross, now in the Court of Appeal, that's at page 245 of the bundle. And again, a similar submission was made as to why the NYP withdrawal clause had to be a condition, because otherwise it was submitted that it would be worthless in a falling market. That was expressly rejected by Lord Justice Gross, who said just above letter C, nor with great respect am I able to accept that in a falling market the right to withdraw is worthless, so that the approach favoured by Mr. Justice Popplewell does not lead to a sensible commercial result. As will be recollected in the COS, Lord Sumption remarked at 7 that it may be in owner's commercial interest to withdraw the vessel, even when market rates have not risen. And so too here, there may be any number of reasons why buyers may went to counsel even when the market has risen. They may have their own internal difficulties. They may wish to use funds for better opportunities. There may be changes in commercial strategy. They may be acquiring vessels for a particular project which is no longer going ahead. The point is that there are a multiplicity of circumstances where a buyer may wish to avail itself of a right of cancellation, even if it is not market-driven. The final point is on the authorities. I've addressed the Solholt. The Al Tawfik is another case on NSF 66 and adds nothing, although in fact in the Al Tawfik perhaps the judge was rather clearer to point out that that was an express obligation. So one sees at page 50 of the authorities bundle. The Al Tawfik. So first of all, this was an NFF 66 form, so the same as in the Solholt. But one sees at the head note, clause 4, the vessel shall be delivered and taken over to safe berth in Karachi within 31st of October 1980. So whilst I take my Lord Justice Nugee's point that perhaps the Solholt was, at least on ground 1, closer to our MOA, the MOA in the Al Tawfik was plainly different. And then, although Malone Friends have replied upon Parbal, the Wan and the textbooks, those weren't developed in any great length, so I simply rest on what I've said in my skeleton. So subject to anything from behind or any questions my lordship have, those are my submissions.
Thank you very much for this.
I have 8 short points. Point 1, my learned friend began and finished by suggesting our case is conditioned by another name. We disagree. One of the hallmarks of a condition is certainty, including certainty in the heat of the moment, as to the parties' rights, obligations, and remedies. There is no equivalent certainty here. All monetary compensation is subject to whether negligence can subsequently be proven. We say a condition to exercise reasonable care is an unfamiliar legal animal, notwithstanding my learned friend's impressive drafting on the hoof in response to a question. Point 2, my learned friend's analysis of the purpose of, on the one hand, the not before provision, and on the other hand, the cancelling date, looked at the matter only or too heavily from the buyer's perspective. We say from the perspective of what the seller is obliged to do, those two dates bookend the timing of the seller's obligation to tender NOR and be ready. Point 3, in terms of the meaning and effect of the laden voyage clause that was addressed in the award at paragraph 57 on supplementary 16, in similar terms to the way it was put by my Lord Justice Phillips, and there is no appeal against that. It may now be common ground that the laden voyage clause does not change what would otherwise be the effect of clauses 5 and 14. Point 4, my learned friend emphasises the damages buyers did recover for the first phase of negligence. They were only substantial because the buyers did accept an extension of time and the sellers had put forward a cancelling date which was 2 months almost after the original cancelling date, allowing them the time to perform or try to perform the Vale charter meanwhile. In the relatively simpler case of cancellation after an original cancelling date missed by reason of proven negligence, a claim for loss of profits prior to cancellation will be measured in days given the need for prompt cancellation. That is why we say on the judge's position and seller's position, clause 14b is practically illusory. Point 5, assuming there is a delivery obligation, my learned friend's case on the role of 14b has changed from one of preservation to one of exclusion. It cannot be both. My learned friend still uses the word preservation, but the substance of his submission is not about preservation. Clause 14b is not preserving anything in terms of accrued damages. It is only excluding accrued damages claims for non-negligent breaches of contract. So the concept that clause 14b is preserving anything is incorrect unless the word preserving is stretched beyond all meaning so as to mean not also excluding. In summary, on seller's case, 14b is an exclusion clause and no more. My learned friend later said that clause 14b is the equivalent of the common law position where there's a pure cancellation clause. See his references to Professor Peel's article. But then clause 14b is conferring no rights on buyers. It is only excluding rights in the event of non-negligent failures. It is a very odd way, clause 14b, to word an exclusion clause, all the more so when subject to proven negligence, the recoverable loss and all expenses is so widely worded. Still on point 5, financings and bulldog is not a common law rule into which I run. It would be if we only had 14a. Financings and bulldog did have an express damages clause, but on the House of Lords authority in Bridge and Campbell discount, it was held to be an unenforceable penalty. So the owners were seeking loss of bargain damages premised on a bare cancellation right. Excuse me, the equivalent of 14a. We do not. We seek them on 14b. Nobody suggests 14b is penal. Point 6. The implied obligation to deliver within a reasonable time is inherently uncommercial. It is an uncertain answer to the question of by when must sellers deliver. It is common ground that question requires an answer, i.e. there is an obligation to deliver by some point. First, reasonable time has been legislated for by the parties in the MOA by giving a cancelling date. Secondly, if the sellers reasonably require more time due to supervening events beyond their due diligence, that is the clause 5C extension of time regime. So to have this implied obligation to deliver within a reasonable time would cut across and undermine the clause 5 regime. It's not the answer. Point 7 and clear words. As to Novison and Alimenta, A, the point in Novison was whether loss was recoverable under the express damages clause where no loss had in fact been suffered. See the end of paragraph 17. B, we don't accept that any presumption survived Bunge and Nadera. The relevant presumption in Bunge and Nadera was that I identified earlier in paragraph 26. Lord Sumption then did deal also with Novisen and Alimenta at paragraphs 34 to 35. That's page 158 of the bundle. And while agreeing with the answer in principle given by Mr. Justice Popwell in Novison, there was no adoption of a presumption. And in particular, no adoption of a presumption that is different to that already set out by Lord Sumption in paragraph 26. As to the Spa Capella dictum, that also goes nowhere. A, Spa Capella had no express damages clause, so the point wasn't an issue. B, the point is not mentioned at all by the Court of Appeal in their Spa Capella judgment. Point 8, my learned friend's final time charter analogy to justify what was otherwise an apparent acceptance of a commercial imbalance is again problematic. Time charter is a contract for services paid for usually by advance instalments. It is a relationship over time, even if not a relational contract. An NSF MOA is a contract of sale. It is a one-off coming together of the parties. There is no analogy, commercially speaking, that buyers should hang on and wait and see whether sellers can come good in the way that owners might have to continue providing the services of the vessel to recalcitrant charterers who are paying a little bit late or a little bit short. The analogy just doesn't work because fundamentally these are different types of contracts. Unless there are any questions, that's the reply.
Can I just ask you, this one, I think, in some ways I think goes to the core of Mr. Wright's case. The phrase due compensation. Mm-hmm. We haven't really discussed too much what actually that means. Due, in what sense? Due, why, to whom, etc. But as it is accepted here, that this is not an accepted repudiation case, not a classic loss of bargain case, but is the exercise of a contractual right to cancel. If there is in fact no loss of bargain in a classic sense, why is due compensation, why does that include damages for loss of bargain? Why are those damages due if there was no loss of bargain?
Insofar as that focuses upon the word due, we say it fails to read the clause as a whole. The phrase due compensation is an old-fashioned phrase. It was in the NSF 66. So we see it in the Solholt. And all the points that arose in the exchanges, in particular with my Lord Justice Nugee, could then be made about the changes of wording in relation to non-fulfilment of the contract.
That's an answer, but not really to my question.
Well, we say it is because we say that what that word did not do at the time of the sole hold and still does not do now is have the effect that when we ask what is compensation for their loss and all expenses, we are asking what is already due as at the time of cancellation. It does not mean that. It does not mean that we look at what would be due if there was only clause 14A.
Let me phrase it another way. Why are damages for loss of bargain due if there is no, on a proper analysis, there was no loss of bargain?
Well, there is a loss of bargain, in fact, and it is caused, in fact, as the tribunal have held, by the failures to tender NOR and be ready. And what we're then engaged in is a question of construction. What does clause 14b mean? And the dilemma is between, we say starkly, a case presented by sellers that, whether because of the word due now or more generally, clause 14b does not give buyers anything they wouldn't already have under clause 14a.
I understand that, but why should it include loss of bargain if there is, on a standard analysis, no loss of bargain?
Because it has to be given content.
So it should be taken to be a loss of bargain. Is that what you're saying?
Well, it has to be given content. It's not just an exclusion clause, as my learned friend suggests, because that's not what it says. It has to add to the remedies that would otherwise exist.
Did you say it's analogous to a loss of bargain then?
What we say is that the overall phrase, due compensation for their loss and all expenses, doesn't mean what was already fallen due at the time of compensation. It means appropriate compensation for their loss and all expenses. And what is appropriate compensation for their loss and all expenses is to be construed having regard to the requirement to give content to clause 14b and for it to do more than just leave us with accrued damages that would have been required. Anyway, my learned friend says we can give it content, but
and
I
you say that it's appropriate that you should have the same damages that you would have if there had been a loss of bargain. Is that the argument?
No, we say it is appropriate that, with the same outcome, but we say it is appropriate that we have loss of bargain damages where they have in fact been suffered by reason of the failures. It comes back to what the ratio is of financings and bulldog. The way in which that is reasoned by the Court of Appeal is to say that in the event of a pure cancellation right, the exercise of the option to cancel breaks the chain of causation. And the question is whether clause 14b just leaves one in that situation, or there is...
Well, it says whenever you exercise a contractual right of termination, you have, in a factual sense, lost the bargain because the contract's been terminated. But we know it's not legally, that's not what we mean by a loss of bargain in the context of an accepted repudiation. But you're saying that you are entitled to what you would be entitled to for a legal loss of bargain, even though what you have suffered is a factual loss of bargain.
Yes, we do say that. And the synonym is market damages. That's the phrase that was used before the tribunal. And what we do say is that in order to give clause 14b any content beyond as a pure exclusion clause, it must extend to market damages. Otherwise, nothing is there beyond perhaps the phrase all expenses.
Yes. Thank you very much. Okay. Well, thank you all very much indeed. A very interesting argument, and thank you not only to leading counsel but to all those behind the counsel and solicitors who know a lot of work goes in all round. We will, it won't surprise you to know, be reserving our judgments. They will be circulated in draft in the usual way for you to correct our grammar, etc., not for re-argument. And it will be subject to the usual embargo, and you know the strictness of that and the approach taken. The hand-down will be electronic, no attendance required, the usual way. And we'll invite you, as per the rubric which you'll be sent, to submit an agreed order if possible, and if anything's not agreed, then short written submissions, which we will deal with on paper in the usual way. Thank you very much.
All right, able.